All rise. Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Please be seated. I am calling cause number 04220029 CR Shaun Andrew Haga versus the state of Texas. Announcements, please.
Morning, Michael Gross, Mr. Haga.
Mr. Gross, how you doing?
Morning, Your Honor. Joshua Summers for the state.
How you doing, Mr. Summers? Do you want to proceed?
Good morning. Once again, Michael Gross for Shaun Haga. I represent the appellant out of the 454th District Court, Medina County, Texas. With the court's permission, today I'll orally argue points of error 1 and 2 and rely upon my brief for the remaining point of error. I've reserved 10 minutes for a rebuttal.
That'll be fine.
So in this case, it is undisputed, completely undisputed, even in the government's briefing, that the victim's daughter, Miss Ortega, told the government pre-trial and during trial that Mr. Haga is not a bad person, that drugs and alcohol did this to the defendant, Mr. Haga. This is where drugs and alcohol get you. And briefly, but not completely, her words, she said she told the government pre-trial that she forgave the appellant. But again, she said that was briefly and not completely. In this particular case, it was a murder case. Mr. Haga was offered 35 to do. The jury gave him 30 to do. However, during the victim impact statement at the end of the case, trial defense counsel was surprised that the victim's daughter got up and in the victim impact statement, which we all know is not recorded, and it's after the sentencing in the case, she said these things, that drugs and alcohol do this to you. Shaun, you look good. I hope you get sober, and I forgive you. So here's where we are today. The judge decided that she was going to deny the motion for new trial in point of error 1. And the judge gave 2 reasons at the tail end of the motion for new trial hearing. The 2 reasons she gave for denying it was, 1, that she felt that Ms. Ortega just spoke from the heart impromptu on the victim impact statement. And 2, she said that trial defense counsel could have interviewed Ortega and found out this information for himself to use for Mr. Haga. Yet it's clear, it's unrebutted in this case at the testimony in the motion for new trial hearing that the trial defense team contacted or attempted to contact Ms. Ortega about 6 months prior to trial. They left, they called her number.
Does that really matter, though, on the issue of whether this falls under Brady, and if it does, whether it's material? Let's talk about that, because we all understand, we read the record, and we know that defense counsel did not know about this, period. So if we part from that basis, tell us.
So, a great example, Justice Alvarez, is the Eggers case that I cited in the brief, where the question is, the government had one of the witnesses' prior criminal conduct, right? Their criminal record. And in Eggers, the question was, look, is this Brady evidence? I mean, is this something the defense could have found out on their own? And the Supreme Court in Eggers had no problem with that being considered Brady evidence. In fact, they didn't even write about that in Eggers. In this particular case, Justice Alvarez, I think that the trial judge in denying the motion for new trial looked to see if reasonable diligence was used by trial defense counsel to get this information from Ortega. I don't think it matters, Justice Alvarez, because it's clear that Ortega told the prosecution prior to trial and during trial these favorable things about Mr. Haga, which clearly is Brady evidence, clearly.
So if the state had, or the DA's office had the, I guess, the responsibility under Brady of advising defense counsel of these statements, does it matter that it was an oral statement versus, a written statement?
Great question, Justice Alvarez. I don't think it matters. I mean, an oral statement is still information in the possession of the state and possession of the government. They had that information. The defense did not. I'm sure somewhere in their file, it was reduced down to writing somewhere. There's no testimony about that. But it's clear that that information was provided to the state orally by Ms. Ortega. But even though it's orally provided to the state, they still had that information. I'm not aware of any case law, Brady, Bagley, Giglio, Aggers at all, that requires that there must be something in writing to be considered information in possession of the state or the government that must be turned over to the defense pursuant to Brady. And so it's our position that,
It falls under the umbrella.
Your Honor,
It falls under the umbrella.
exactly.
Okay.
That's
Now, if it
exactly.
falls under the umbrella, tell me, why is it material? I mean, you have other testimony there, testimony of the guards.
Incredibly weak testimony. But looking at it as objectively as possible, true, I'm Mr. Haga's counsel, I'm kind of in gladiator mode, but trying to look at it as objectively as possible, what do we have? We have 3 guards that came in from the jail and talked about trustees at the jail and how trustees are treated at the jail. And that the fact that trustees at the jail, they get tasked with sometimes bad duties at the jail, like cleaning out the urinals or whatever. But that's it. That's all that came. And then there was Mr. Haga's brother who testified, but that didn't even come close to the amazingly wonderful evidence that Ortega gave the state prior to trial in saying that, I'm glad you look sober. This is what drugs do to you. And you're a good person. I mean, that is amazing. I mean, you're a good person is just, for a jury to have heard that in a murder case would have been extremely helpful.
I have a question. What was the relationship between Mr. Haga and Nicole? I mean, did they know each other? Were they friends? Was it a family friend? It's not very clear from the record.
So it's my understanding, small neighborhood, everyone kind of knows each other.
Okay.
I mean, it's clear from the record that Miss Ortega knew that Shaun Haga had a drug and alcohol problem. That's crystal clear in the record.
Yeah, it is.
And so a city like San Antonio, you would have to practically be next door neighbors. And even then, good luck knowing something like that about a neighbor. But it's clear in this case, in Medina County, down there in that county, it's clear that Miss Ortega knew Shaun Haga and that, and she knew he struggled with drugs and alcohol. And that she said, you're a good person. And this is what drugs and alcohol do to you. And that's.
But when she was really talking about the future, she was saying in her statement, as I recall, I hope that this teaches you a lesson. And when you get out, you become a good person.
I know at the beginning, she said, you're a good person. She said, I hope you get sober while you're in prison,
Right.
while you're in there. And I think that's what the trial judge focused on is I hope you get better while you're in prison. And, the question whether or not she told the state that she forgave Shaun Haga, it's our opinion that whether or not she used the actual words forgave, it's clear she gave this information to the prosecution pre-trial. So even if she said during the victim impact statement, these things that the judge viewed were from the heart and, extemporaneous, if you will, in the moment, it's unrebutted that it was given to the state pre-trial and they had that information.
And it should have shared. Let's talk about material. Was it material? And the CCA is very fond of harmful error. Do we apply it in this case to see if it's material? I mean, what is the standard we apply?
Sure. So, of course, to be fair, we have 2 standards, one in point 1 and one in point of error number 2.
Okay.
And talking about the standard in point 1 is, so deference is given to findings of fact, if any, by a trial judge.
Mm-hmm.
Only if those findings of fact are supported by the evidence in the record. On the other hand, de novo is your court's burden to look to see the materiality of Brady. So it's clear under the case law we cited in our brief that you all do a brand new look at the materiality of the the evidence that the state failed to turn over.
What about harmful error? Do we apply it in any way here compare the statements of the brother and
And the
guess
three
the
guards.
deputies, the jailers, to Nicole's statement? Do we do any type of balance there?
Our position on our side is there's Brady violation. That's error that necessitates a new trial. There's no harm analysis. 44.2A constitutional error. That's our position, unless you find beyond a reasonable doubt that it did not contribute at all to the harm in the case.
Mr. Gross.
I'm sorry.
No, go ahead. Judge.
So then tell us about outcome.
I'm sorry,
Tell us about outcome. So
what
you've
should happen?
You're explaining to us about materiality. Tell us about outcome. How would this outcome have been different had this information been turned over to the defense?
So obviously he's looking at murder, as you all well know, 5 to life. And he gets 30, which is a lot of time, especially on, this particular case. I mean, the problem is that it could have been a lot less, as we argued in our brief, had this very favorable evidence come out from the victim's own daughter, and the jury heard her say, Shaun Haga, I know you're a good person. This is what drugs do to you. I forgive you, or words to that effect. She kind of hemmed and hawed on that. But it's our position that the outcome would have been less than 30 to do had this favorable information come out. Now, let's assume that some teachers or coaches or neighbors had come in to testify, hey, this is the Shaun I knew before drugs. This is the Shaun Haga I knew after drugs. He's a good person, things like that. But 3 jailers come in, one of whom didn't even know Shaun. The other 2 said, yeah, he's done a good job as a trustee. Well, that doesn't give you much. He's studying the Bible, things like that while he's in the Medina County Jail. That doesn't get you the information you would get in like a death penalty case where you've got mitigation evidence and you're hearing this good, favorable evidence from the victim's own daughter. There's not anything that should persuade this court that was anything but harmful to Mr. Haga and would have resulted in less than 30 to do. Now, I mean, he didn't get 60, 70, 80, what you see in some murder cases. He also didn't get 10 or 20 like I've seen in some murder cases, that you see on appeal. It's our position that, look, there's not evidence to convince this court, beyond reasonable doubt, that this error would not have affected the sentencing in the case, which is what our position is. When you do your de novo materiality review and consider the outcome of this case.
Mr. Gross, it's clear to me that it's your position that this clearly falls under Brady because you've used clearly several times. So we get that that's your position. However, you're focused on the fact that this is simply Brady evidence or falls under Brady. There's a violation. I do believe that you have to get further than speculation. And that's where I am right now. So convince me otherwise, please.
With respect to this evidence?
Yes.
Well, I mean, a review of the record doesn't show what Shaun Haga was like before the killing in this case, before the murder in this case. No evidence, 0. So the jury just hears that this guy killed the victim in the case. They don't have any background whatsoever about what happened at sentencing, about what happened to Shaun Haga that made him become this alcohol, drug dependent individual that changed him, even though the defendant's daughter knew he was a good person. And so how did Shaun Haga get to that point? That's the huge missing link, Justice Chapa, in this case, because the jury is sitting there saying, well, all we know is this is, as far as we're concerned, some thug in the neighborhood, high on drugs or whatever that killed this guy. We find that aggravating, not mitigating. However, if they had heard from the victim's daughter, Miss Ortega, that she says to the jury that Shaun Haga is a good person, that drugs did this to him, that I mean, glowing words like that from the victim's daughter. It's our position, Justice Chapa, that's huge mitigation evidence for a jury to hear that would have caused an even lesser sentence in the case. But that whole link is completely missing in this case when you just have three jailers from the jail coming in and talking about a trustee program that really that doesn't help you. That doesn't explain
Doesn't take it
what
back.
he was like before the shooting. His brother came in, but really frankly, that was, at best tepid information from the brother. It didn't go anywhere near to the point where, hey, this is what Shaun was like growing up. This is what the household was like growing up. This is what mom and dad were like growing up. But even more importantly, Miss Ortega, she says Shaun was a good person. And before he got into these drugs and whatnot, that's clearly, Justice Chapa, in our opinion, the missing link that would have resulted in less time in this case, especially since 44.2A, the constitutional error, that doesn't get you all enough information on what the evidence is from the motion for new trial in this case and at trial. It should cause this court huge concern. The fact that this Brady evidence wasn't turned over to the defense, so they, especially since it's clear that, and it's unrebutted, the defense tried to contact Miss Ortega prior to trial with no luck. And, trial defense counsel approached Miss Haga during trial, but clearly got the indications from Miss Ortega that I don't want to talk to you guys. She didn't come out and say that. That was clearly the implication.
And it was also respect. What
Ma'am?
about your second? There was also respect on the part of Mr. Duarte.
Exactly.
What about your second issue?
So point of error 2. It dovetails with point of error 1, obviously. But however, you have that 3-pronged Brady test that you look at in point of error 2, instead of the 44.2A constitutional test. And so the 3-pronged Brady test, question number 1, did the prosecution fail to disclose that evidence? Whether good or bad faith, did they fail to disclose the evidence? It's unrebutted in this case that they failed to disclose that evidence. Point number 2, was the non-disclosed evidence favorable to the defense? 100%. There was no downside to Miss Ortega coming in and testifying. I mean, that kind of information, you're not a bad person. The drugs and alcohol did this to you. This is what you get with that. It's clearly favorable to Mr. Ortega. And then the third point, which we've talked about, is materiality. Is there a reasonable probability that had the evidence been disclosed, the outcome of the trial would have been different? In other words, and we quoted this in our brief, is there a reasonable probability, is one sufficient to undermine confidence in the outcome of the trial? And that's what we've been talking about in point of error 1 a little bit with materiality. But this court, we respectfully suggest, should have a great concern on whether the outcome of the proceeding, whether this Brady failure to turn over this Brady evidence undermines confidence in the outcome of the sentencing case of 30-2. And so it's our position that under point of error 2 is that had this information been turned over to the defense, it would have been material. In other words, the jury receiving this evidence, especially given the lack of evidence that the jury had at sentencing with the 3 jailers and the brother, it would have, this court should think that there's not confidence in the outcome of the sentencing of this case. And, of course, we're not asking for a new trial. We're asking only for a new punishment hearing on this for the Brady violation, which is clearly allowed under the case law with Brady and his progeny. That it doesn't just have to be a new trial that the Brady evidence could affect. It could also be the sentencing in the case. And so it's our position that a new sentencing hearing would be appropriate for Mr. Haga in this particular case. And so that's everything that I had to present. Unless there are any questions, I want to thank you all so much.
Thank you, sir. Mr. Summers.
Morning. May it please the court.
It does.
My name is Joshua Summers. I'm with the Texas Attorney General's office, and I'm here on behalf of the state. This court should deny appellant's first 2 points of error because no Brady violation occurred with respect to Nicole Ortega's allocution statement. Before addressing the specifics of this Brady claim, it's important to recognize the policy implications that this court's decision will have on crime victim rights. Requiring crime victims to disclose their allocution statements, testify on the record as to those allocution statements, and be cross-examined about them will have a chilling effect on crime victim rights because it would deter individuals from participating in the process who might otherwise do so. At the motion for new trial hearing, Nicole Ortega was compelled to testify in direct violation of Article 42.03 of the Code of Criminal Procedure. And in effect, she forfeited her rights as a crime victim. Brady requires three things. It requires that evidence within the state's possession be withheld from the defense. Second, it requires that that evidence be favorable. And third, it requires that it be material. In other words, but for the withheld evidence, the outcome of the proceeding must have been different. In this case, the trial court correctly determined that Nicole Ortega's victim allocution statement was a result of a process in her own mind and heart, and that she did not know what she was going to say until she actually got up on the stand and testified at the conclusion of the trial. This finding is a factual finding, and this judge is entitled to deference for those credibility determinations and for any conflicts in the record. Her finding.
Let me interrupt you. So what you're saying is this is a different type of case because Nicole's thought process evolved during the trial, and then she came out during the punishment phase and said whatever she did.
Correct.
Was there any, is there any doubt that those feelings were also said to the DA or to the investigator before the trial even started?
Absolutely. I respectfully disagree with the appellant's argument that this information was within the state's possession. You know, what we're talking about here.
And that's what intrigues us, by the way.
Okay. Yes, Your Honor. I mean, this is a statement, and this is reflected in the record, volume 7 on pages 10 and 11. This is a statement that was never reduced to writing. This is coming from a person who is reflected on pages 12 and 13 of the record, experienced a range of emotions and sentiments from anger to hate to forgiveness to sadness. And most importantly, and this is reflected again on page 13 of the record, trial influenced what she was going to say. And that's why the trial judge made the decision that she did, okay, in evaluating that witness's credibility. And one of the important things to look at in terms of whether or not this information was withheld are the specific statements appellant through counsel argues that the state did not turn over. Mm-hmm. And so when you look at those specific statements, the record does not indicate that the state was aware of them. So for example, the argument that the state knew that Ms. Ortega was going to say that she did not think Mr. Haga was a bad person and that he was not the kind of person that would commit such acts of violence. Well, on page 7 of the record, Ortega denied that she had previously stated that appellant was not the type of person who would commit such an act of violence. In fact, when specifically asked, so you thought this was out of character for Mr. Haga, her answer was, I have no idea. And although she knew this man, this was not someone that she was familiar with. On page 14 of the record, she said her last contact with Mr. Haga was 8 months prior to this incident.
Hold on for a second. Please come in.
I proceed, Your Honor.
Proceed,
Thank
Mr.
you.
Summers. I'll give you a minute more.
It's okay. The next specific statement, when you walk through those specific statements that appellant argues the state knew about but did not turn over, was this argument that drugs and alcohol made Mr. Haga act atypically. The problem with this, though, is again on page 6 of volume 7 of the record, Nicole Ortega stated that she believed that drugs were involved in this based on her own personal experience using drugs. And on pages 13 through 14 and 16 of that portion of the record, she said she had no actual personal knowledge of the role that drugs played in Appellant's murder of her father. And all of this goes to why these statements, not only were they not withheld, but they're not material, because all of these sentiments that we're talking about, these are things that involve speculation, impermissible opinion testimony, and it's coming from a witness who lacks personal knowledge about these things that they're arguing the state withheld. And, again, not only does the record not support those first two specific allegations, but moving forward to this sentiment of forgiveness. Well, her own statement on its face says, "Today, I have decided to forgive you." And that goes back to what I said just a moment ago. These are sentiments and feelings that she developed after going through this process and sitting through this trial. And she specifically said in the motion for new trial hearing that she did not arrive at this sentiment of forgiveness until she had actually sat there and heard all of the testimony. And so, again, when you go through those specific statements, the record rebuts each one of those specific allegations that appellant raises in his brief. And so, therefore, the trial court correctly found that the state did not know and could not have known this information and therefore could not have turned it over. So first and foremost, that initial prong of Brady is not met. Again, when you look at these specific statements of whether this is out of character, whether drugs and alcohol made him do this, and whether she forgave appellant.
Assume with us that this panel decides that it was a Brady issue. Tell us about the third prong of the test of the Brady test,
Sure.
Material. Why weren't they material?
And that's also key to the court's decision. Obviously, for materiality, there must exist a reasonable probability that the outcome of the trial would have been different. Well, all of these things it's improper opinion testimony, and allowing information like this to come before the jury would allow Nicole Ortega to in effect function as a 13th juror, because talking about whether or not a next of kin, a family member forgives a defendant, that's tantamount to asking what that person thinks the appropriate sentence would be. So, for example, conversely, the state certainly could not call someone to testify that they condemned a defendant, okay? Because again, that would be invading the province of the jury. That would be improper opinion testimony. And really, when you apply 42.03 through the lens of Brady, that's really how you know the materiality prong is not met. Because 42.03 specifically provides that victim allocution statements are to be made only after punishment has been assessed and after sentence has been pronounced. I mean, this again, just to bring it back to where I started, is a right afforded to crime victims. This is an unsworn statement they are permitted to make at the conclusion of trial, because this isn't necessarily just about a murder case, but it's about a real person who experiences real feelings sitting through a trial about the loss of a loved one. And that's why we have this statute.
Correct. Mr. Summers, I don't think Mr. Gross would agree with you. I mean, wouldn't disagree with you rather on what a victim impact statement is. I think if we're truly narrowing our focus here, it's whether the prosecution had any type of evidence that falls under Brady prior to trial.
And
so if you can kind of lean into that a little bit and share with us why you believe the record shows that the prosecution did not have this information prior to trial.
Well, the only discussion about any potential Brady information, or the only, I guess, allusion to any potential Brady information is elicited through vague, broad, non-specific questions. But again, when you get to those specific facts that the defense now seeks to introduce, those facts were unknown to the state. Those specific statements about whether this was out of character, the record does not support that the state was aware of that. Whether drugs made him do this, the record also does not support that the state was aware of that. And finally, the sentiment of forgiveness, again, was something that she didn't develop that sentiment until finally at the conclusion of trial. And so there is really no evidence that any of this was within the state's possession, and therefore there's no evidence that any of these specific things were withheld from the defense.
What is your response to whether, let's assume that it was in the state's possession. Is there any relevance to whether it was oral or materialized in or
No.
memorialized in document?
For purposes of Brady, it would not matter whether it was oral or written. I agree with that. But I think just to take a step back, the problem with this issue here is the remedy that appellant seeks is one that cannot be obtained. These statements, first of all, are statutorily protected under 42.03. But secondly, the Court of Criminal Appeals, in acknowledging 42.03, has held, and this is in the Johnson versus State case, a 2009 CCA case, which is cited in the state's brief. In that decision, the Court of Criminal Appeals acknowledged that 42.03 victim allocution statements are to be made only after sentencing to alleviate any risk that the statement might affect the partiality of the fact finder at the punishment phase. The Court of Criminal Appeals further acknowledged that victim allocution statements are to have no effect upon the judge or the jury's decision-making. So based on this decision and the plain reading of the statute, there is really no materiality issue here because there's no reasonable likelihood that the outcome of the trial would have been different because such statements are not admissible. So again, the remedy they are now seeking, a new punishment trial, is one that cannot be obtained because they cannot offer these statements into evidence. They're inadmissible statements. So therefore, they could not have affected the outcome of the trial.
So I guess what you're saying is assume that it does constitute a Brady statement. Nonetheless, it's no evidence because they cannot affect the punishment either by the judge or the jury pursuant to 42.03.
Correct. So, just from an evidentiary standpoint, this would be improper opinion testimony. This is evidence that is statutorily protected under 42.03 and is barred from being admitted per the CCA's opinion in Johnson versus State.
Okay, Mr. Summers, my question for you is, you're correct. But if a victim's family comes in to law enforcement and or the DA's office, and they discuss with the prosecutor and or law enforcement something that's favorable to the defense, whatever that is. And it's not a victim impact statement. It's simply statements about the relationship between the parties, the relationship that person had with the defendant. Are you telling us you would not turn that over?
No.
You would not be required to
No.
turn that over because it
Your Honor.
doesn't fall under 4203?
That is absolutely not what I'm saying. Okay. Obviously, the best practice is always to turn everything over. Absolutely 100% agree with you. But the issue here is these statements, once again, there's no evidence that these specific statements were within the state's possession. And that is why the trial court made the finding that it did, that this was the result of a process in Nicole Ortega's own mind and heart. And the judge, having sat through all of the testimony from jury selection to opening statement, guilt innocence testimony, closing punishment testimony, sitting through all of this, was in the best position to make that credibility determination. And the trial court correctly determined that the state did not and could not have known what Nicole Ortega was going to say because she herself did not know until after she'd already sat through the trial. So although, yes, had the state known these things, it's always the best practice to disclose this information to the defense. And I know Mr. Barr, and that is certainly something he would have done if he had had this information, but the record does not indicate that he did.
There's nothing in the record that would indicate that the state or that Nicole Ortega gave a statement to the prosecution. That's what you're saying?
Well, I'm saying with respect to these specific allegations that the defense, that appellant claims that the state did not disclose.
Didn't she say that that's what she told the prosecutors?
Well, I think that the record indicates that she briefly told the prosecution things, but that's never really flushed out as to what those things were. Invariably in preparing for a trial, the state has numerous conversations with a family, and invariably different things are said about what to expect, what to anticipate in the course of a trial, the potential outcomes and things of that nature. But in this case, those specific allegations made by appellant that Mr. Haga was not a bad person, that drugs made him act atypically, that she forgave him, there is no evidence that those specific statements were within the state's possession.
So Mr. Summers, I'm getting, I feel like I'm being misled a little bit, or I'm not on the same page. I almost feel as if you're saying Ms. Ortega did meet with the prosecution prior to trial. However, she did not make these statements prior to trial.
That's what the record indicates, Your Honor. So with these, it's in the.
Okay, but hold on, but it almost makes it seem as though you're saying that there was no type of contact with Ms. Ortega and the prosecution prior to trial.
No, that's not at all what I'm saying.
Okay.
The
Let me
record.
clarify that for me, because I don't want to leave here thinking that there was a play on words.
No, and that's certainly not my intent at all,
Okay.
Your Honor. So certainly there were conversations had leading up to this trial, but it's unclear what was discussed in those conversations. And I
Why
think
is it unclear what was discussed in those conversations?
well, I think the most that Nicole Ortega ever really acknowledges is that she briefly told the state things, but that's never really flushed out what she specifically told the prosecution. And so I think that's kind of important in the court's analysis today, is that in the motion for new trial, there are very broad, vague, non-specific questions asked on direct by counsel, but when questioned by the state on cross-examination as to the specific things that were specifically said in her allocution statement, she denies that she told the state each one of those things, or rather the record does not support that she told the state those specific things, the bad person statement, drugs and alcohol and forgiveness sentiment.
Thank you for that clarification.
Yes, Your Honor.
In the record, does she say she remembers telling the prosecutor that she did not wish Haga ill will? She wanted him to have a better life because she understood from her own experiences how drugs could take somebody's life apart, and that she herself had once been incarcerated. She wanted him to have a better life. So there's no dispute that she told the prosecutor that, correct?
Well, I will acknowledge, I think
In the
there's.
record.
No, yes, yeah,
Okay.
in the record,
Yeah.
correct. But there's some conflict in the record, because later on, while under question by the by the prosecutor, she states that her belief that drugs were involved in this was based on her own personal experience, and that she had no actual personal knowledge of the role that drugs played in Appellant's murder of her father. So a lot of what we're talking about here is based on that witness's, if you would call her that, speculation. And so really, this isn't, I would submit this isn't really evidence of anything. This is her opinion and speculation about what role drugs and things of that nature played in the case.
But her opinion and speculation, and let's talk this, set aside speculation, her opinion, if she told the prosecutor that before the punishment phase, is important to the jury. And that is, she can have a personal opinion.
Well, again, I think that in large part goes to the materiality analysis, because when you talk about.
Excuse me, because, and I'll give you your minute.
No, it's okay. It's okay.
Excuse me, because now you can see why we're confused.
Sure,
okay?
sure.
Her opinion, if I say, this color is nice and I love this color, okay, and I forgive anybody who painted it gray, okay, isn't that my personal opinion? Isn't that a statement that is made? It might not be evidence like
Sure.
we know it.
Sure.
It might, but it's my opinion.
Sure. And so I understand that, but this opinion, I guess if we're talking about that word forgiveness, is one she did not arrive at until she actually made that allocution statement.
Take forgiveness out, but take the other parts of her opinion, into consideration. I mean, she put herself in the shoes of this man even before. She knew what it was to be a drug. She understood. Isn't that kind of some empathy that the jury should have heard?
Well, and I can see what the court's saying, absolutely.
And I'm just,
no,
I'm playing devil's
just- no,
advocate here
that's
because we
absolutely-
have problems with this
Sure,
case.
sure. And I think that the issue with that is she didn't have any personal knowledge of whether or not drugs played a role in this murder, and that her speculation about the role that drugs may have been involved was based on her own personal experience and not on any familiarity with Mr. Haga. So I think that's the problem. And again, one of the reasons why these types of allocution impact statements are statutorily protected is because so much of what she talks about is speculation and opinion testimony. And so much of what she talks about, she doesn't have personal knowledge of.
It comes from the heart.
It comes from the heart. Exactly.
So the issue here is, were her statements prior to the punishment phase, did they come from the heart also, and should have they been disclosed?
Sure. I think I follow what the court's saying. Yes. But again, with these specific statements, these specific things raised in the brief, the record does not support that she ever told the state any of these things. And look, obviously the best practice is always to disclose any sort of thing that may come across as favorable. So certainly had she made these specific statements to the state, that's something that the best practice would be to provide that information to the defense. But it's because these things are, again, opinion, speculation, things that she lacks personal knowledge of. That's why the law is the way it is, because she is speaking from the heart, putting herself in the shoes of Mr. Haga. And to me, the problem with all of this taken together is not just that she doesn't know these things to be true about the defendant, but to ask someone to proffer these types of statements would effectively allow her to be a 13th juror. Because the state, again, certainly the state could not call someone to say, do you condemn this defendant? Because when you ask questions like that, it's tantamount to invading the province of the jury by suggesting what sort of punishment the jury should give. And that's the real issue here, is neither side can sponsor a witness to talk about what they think the appropriate punishment should be. And when you talk about these sentiments, not only are they heartfelt and personal in nature, developed over the course of the proceeding and the course of trial, but these are things that beg the question of what do you think the appropriate punishment is, which is inadmissible.
Mr. Summers, I have a quick question. This is speculation.
Yes, ma'am.
If we were discussing the guilt innocent phase versus the punishment phase, would we have a different case here? Or is it irrelevant that we're talking about Brady in the punishment phase?
I as I stand here today, I can't think of how, even if you were assuming arguendo that this would in some way be admissible in punishment, I don't see how it would be admissible in guilt innocence necessarily, because this at best, and again, this is just assuming arguendo, this would be character type evidence or opinion type testimony. This is something.
If it were considered character type testimony, why wouldn't that be admissible during the guilt innocence phase?
Well, it's I guess that I struggle with the idea that whether or not someone forgives someone or thinks they're a bad person, how those things would be admissible really in either phase.
Well, but if someone is saying, I know this person to be a good person, and drugs got the best of him, and he acted in a way that was not familiar and was against actually, who he is as a person, but he was heavily influenced by drugs. Why wouldn't that be material during the guilt innocence phase?
Sure. So in the guilt innocence phase, obviously the state is required to prove certain elements, and that's what's at issue. Intoxication is not a defense. And so and having tried many cases, this is not the type of evidence that would be relevant, be not relevant evidence, if you would call it evidence, in the guilt innocence phase. It may be something that could, and I would stress that word, could be admissible in the punishment phase, but only by a witness who had personal knowledge of the defendant.
Okay.
I don't know if that answers your question or not, but this would not be relevant by either side for purposes of guilt innocence, really. And again, at most, really in the punishment phase, whether or not you think someone's using drugs and would be a different person if they were sober, wouldn't necessarily be a legal defense to the commission of that crime. And so it wouldn't be relevant evidence in guilt innocence, and it would only be relevant in punishment if there was a witness that one of the parties could sponsor that had personal knowledge and was aware of the defendant's drug use and how he acted when he was and was not under the influence of drugs.
Thank you, Mr. Summers.
I think we
Yes, Your
gave
Honor.
you 2 minutes, but
Sorry.
I want to ask, I want to ask a question, an open-ended question. Is there anything else that you think that might help us decide this issue?
Sure. I think, one of the things that Mr. Gross touched on that I wanted to touch on as well is
And I'll give you your 5 minutes, okay, Mr. Gross? You know that I'm fair here. But this is an important case to us.
is equal access to the
Uh-huh.
witness. And that's another important thing to consider. And it's clear, you can infer from the record that Ms. Ortega was there during the course of trial. She was present for appellant's trial counsel to speak with and ask questions of, whether or not he chose to do that or not, remains to be seen. But that was one of the trial court's other findings, is that trial counsel had equal access to this person. And that's obviously key. And the record is not clear as to whether or not trial counsel made efforts to contact her. In his testimony, trial counsel stated that he did, but in Nicole Ortega's testimony, she stated that he did not. He did not leave her any voicemails, text messages, emails, never sent an investigator to contact her. And this goes to why we have that abuse of discretion standard, why factual determinations go to the state. They go to the trial court because she's able to reconcile those conflicts in
The
testimony.
credibility issue.
Correct.
Yeah.
Yes, Your
Mhm.
Honor. And I think one of the other important facts to point out here when we talk about equal access is that appellant's appellate counsel was able to make contact with her, did speak with her. And I believe that's reflected. All of this is discussed on pages 14 and 15 of volume 7 of the record.
But that's not until after the fact that there might be an issue with respect to Brady, right? Why would a defense attorney go and speak and seek out a victim's child?
Sure. And I think
Unless the prosecution discloses
Sure,
some evidence
sure.
that would initiate that contact.
And I just think that's one other fact in the entire, gamut of facts to consider. But once again, to me, this case turns on the state was unaware of these specific statements. And secondly, this is not material, quote unquote, evidence, if you will. In other words, when you look at Johnson versus State and you look at Article 42.03 and you view those things through the lens of Brady, these are not things that would be admissible in court. In fact, they're plainly barred. And that's an issue that I, as the state, have with this, is that if someone were to attempt to sponsor this information by either side, the other party could object and their objection would be sustained. And so that's my problem with the remedy they're seeking, is it's one that cannot be obtained. If they now want to introduce these types of opinion statements, this type of speculation, it's inadmissible information. And so therefore, it makes little sense to give someone a new trial when what they seek to introduce is not admissible.
And he's not asking for a new trial.
But
just
for
punishment.
punishment,
Yeah,
for
right.
purposes of
Mhm,
punishment.
mhm.
Yes, Your Honor. Thank you.
Thank you very much, Mr. Summers.
Thank you for the court's
Very-
time. Appreciate y'all giving me a few extra minutes.
Mhm. Would you give him 5 extra minutes? I don't think he'll need them.
I don't think I will either. You're right. Couple of thoughts on hearing Mr. Summers. As we all know, DA's office, the AG's office, when they're prepping a case, especially a murder case, they have victim advocates. They have people working for the prosecutors. In this case, you had the AG's office and the DA's office, both involved. Nobody from the prosecutor's standpoint ever testified at the motion for new trial hearing that Nicole Ortega never told us these things. The record is unrebutted. It is clear in this record, Nicole Ortega told the prosecutors these things, or someone on the prosecution team.
Or similar things, because she did not recall the exact words.
Well, and great question, Justice Alvarez, because on page 8 of the motion for new trial transcript, lines 5 through 15, I said, so these thoughts, you shared them with the prosecutors at some point during all the prep on everything. She said, yes. Do you recall how many times you met with the prosecutors? Real roughly, not exactly, about 3 or 4 times. And even prior to court as well. That's unrebutted that she said that she told the prosecutors these things. Now what the government's alluding to in their oral argument here is that, look, Mr. Summers, I'm sorry, Mr. Goff, he asked Ms. Alvarez, you never told me those things, did you? Well, that's not Brady. That's not the prosecution team. You know, Brady goes to even law enforcement. Law enforcement is tasked with providing favorable information to the prosecution to turn over the defense. It's unrebutted in this case that Ms. Ortega told these things, except for the forgiveness kind of language, but she said briefly, but not exactly. But she told this to them pre-trial and during trial. You know, this 42.03 respectfully is a red herring. I'm not asking, it's just taking us down a rabbit trail that really doesn't have anything to do with the facts of this case, because we wouldn't be here had the government followed Brady and provided the favorable information that Ortega gave them to the defense. You know, just because we learn of favorable Brady evidence during victim impact and the fact that that individual said, yeah, I told the government that pre-trial, during trial, that makes it Brady, period. There's no exception to Brady under the U.S. Supreme Court case law. Brady, Bagley, Giglio, Eggers, Kyles, none of those cases say, you know what? There's an exception that if it's a victim impact statement and that's how the defense learns about the favorable evidence, if that was provided to the government pre-trial, that's Brady. Doesn't matter when it's discovered. Usually it's discovered after trial. In this particular case, it was discovered immediately after trial during the victim impact statement. 42.03 has no application to this case whatsoever.
What about the policy considerations that Mr. Summers brought up?
35 years of doing this, I have never had a victim impact statement like this ever. It's always in his face, degrading him, some of the worst, sometimes, or that's kind of a bad way to word it, but it's never favorable. But how does this particular case have any chilling effect whatsoever on victim impact? None, zero. That I can't conceive of a single way that this motion for new trial resulting in the discovery of Brady evidence will have any chilling effect on victim impact. I've seen many,
Well,
and they're never favorable. I'm
okay.
sorry,
No,
go ahead.
Go on.
Mitigating evidence in a case does not invade the province of the jury. You know, the government tries saying today in oral argument, look, you know, now if we put this mitigating evidence in, you know, Shaun, you look good sober, you know, drugs do this to you, you're a good man. That mitigation evidence is not invading the province of the jury. You know, the state says,
Well, it was done before.
I'm sorry.
So it is evidence because it's done before the punishment phase. It's not really, it's like the impact statement, but witness impacts or victim impact statement, but it was done before the punishment. So it does come into evidence, right? Am I wrong in my rules of evidence there?
The mitigating evidence is clearly admissible. That's
Uh-huh.
exactly right. And mitigating evidence at the punishment phase of trial is always admissible. You're exactly right, Justice Alvarez. Always. It doesn't invade the province of the jury like the government tries arguing in this case.
But here, Ms. Ortega provided a statement after punishment was assessed?
There, I'm sorry, did I understand Justice Chapa to say that even if they find the evidence after sentencing?
No, here, did Ms. Ortega provide her statement after the punishment was assessed?
No, pre-trial.
Okay,
She says clearly on page 8, I said, you share this with prosecutors at some point during all the prep?
I'm sorry, my question wasn't clear.
I'm sorry? Oh,
My question wasn't clear. During the punishment phase, right? Did Ms. Ortega provide her statement after the sentence was assessed?
yes, that's exactly right, Justice Chop. So
Okay,
the jury comes back with the sentence, the judge sentences the individual, and then the court reporter stops typing everything, and the judge said, is there any victim impact? Yes, there is. Ms. Ortega came in and gave victim impact. You're exactly right.
okay. I
Justice
just wanted
Chapa.
to make sure I was on the same page. Thank you.
However, that's what led us, which is, you always find out this Brady information post-trial. You always find it out post-trial, usually, because that's when you then come back and say, look, in a writ, on habeas or on a motion for new trial, you're saying, look, we just discovered that this favorable evidence was in possession of the government, and we think that should, and they didn't provide it to us, so we should get a new punishment hearing. And so that's why it's not of any importance at all, the 42.03 argument in this case. It just has nothing to do with this case at all and no chilling effect. The state also argues that, look, we had no idea she was going to say these things in victim impact, and so we shouldn't be held liable under Brady for not turning them over. But that belies the direct testimony by Ms. Ortega on page 8 on the motion for new trial proceeding, that she told them pre-trial these things. It's unrebutted. And to come in now at oral argument and make a bold statement that we never received this information from her, that's completely contrary to the testimony at the motion for new trial hearing. And the government had sufficient opportunity to try to come back and put on their victim advocate or someone and say, look, no one on this team ever heard this from Ms. Ortega at all. It just didn't come in. Personal knowledge of Shaun by Ms. Ortega. It's in the record. Page 6 of the motion for new trial record, line 3, Shaun, you look good sober. It's clearly personal knowledge of her part on Shaun. Page 7, lines 3 through 9. That's from personal experience, right? Yes, and also your experience with Shaun Haga. My experience with Shaun Haga was not a very good one, never a close one. It was always about drugs, and that's pretty much to the point. So she clearly knew Shaun Haga, clearly had personal knowledge about Shaun Haga. That's clearly admissible as mitigating evidence at
Yeah,
the
it
punishment
is, but
phase.
that's in all fairness to Mr. Summers. That's not what Mr. Summers said. Mr. Summers said that she did not know at the time of the incident whether he was drugged or not.
That's true, but I also understood him saying, I may have heard it wrong, and please forgive me if I heard it wrong, but I just thought he said that there's no evidence in the record that she personally knew Shaun Haga. And if I heard that incorrectly, I apologize.
I don't think
that's
you
what I
said
heard.
that.
The last thing I wanted to raise was the last thing raised by Mr. Summers regarding equal access to witnesses. Just because trial defense counsel can walk up to a witness or call a witness doesn't mean we have equal access. And that's the point that Justice Chapa made a little bit ago, where, look, defense counsel calling a victim's daughter on a murder case, you don't have the kind of access like the prosecutors would when they call the victim's daughter to find out information from that individual.
You handle them with clothespins,
I'm sorry?
and you handle witnesses with or family members with clothespins.
Right, exactly. And so based on all that, it's our position, unless there are any questions, that Shaun Haga should get a new sentencing hearing because of the Brady violation. Of course, point of error 3, which don't need to discuss right today, that asks for a new trial. But with respect to points of error 1 and 2, a new punishment hearing. Thank you all very much for the opportunity today.
I'm going to ask you the same question. Anything else that you would like to add? And I know what the answer is going to be, but I'd like to be balanced.
Sure. I think I've covered everything that's in the record. And Unless you all had any other questions, that's everything I had.
Justices. Thank you very much. These arguments were very enlightening to us. Thank you very much both. They were excellent arguments and your case has been submitted and we should have an opinion shortly. Thank you very much.
All rise.
Thank you.
You want to see?